This wasn't a mistake. This wasn't carelessness. This was a deleted post that may constitute the single most damaging piece of evidence Donald Trump has ever created against himself. And the timing is no accident. Whilst nearly 1,000 pages of sealed Epstein documents flooded into public view, whilst Trump's name appeared in depositions he hoped would remain buried forever, whilst prosecutors in the Southern District of New York reviewed evidence connecting powerful men to systematic abuse, Donald Trump posted a denial to Truth Social. Then he deleted it. Not edited, deleted. Erased from existence within hours. We have obtained the screenshots. We have analyzed the legal implications. We have consulted former federal prosecutors. And what we have uncovered reveals consciousness of guilt so blatant that criminal defense attorneys are calling it prosecutorial malpractice by the defendant himself. Click the link below. You must witness this before the indictments drop. Washington District of Columbia, February 1st, 2026. The Capitol woke this morning to revelations that legal scholars are characterizing as potentially the most significant evidentiary development in any investigation touching Donald Trump since the seizure of classified documents at Mar-a-Lago. On January 3rd, 2025, a federal judge in the Southern District of New York authorized the unsealing of approximately 973 pages of previously sealed court documents stemming from the defamation lawsuit Virginia Giuffre versus Ghislaine Maxwell. These documents, locked away from public scrutiny for years pursuant to confidentiality agreements and protective orders, contain sworn depositions, witness testimony, flight logs, party guest lists, and calendar records connecting numerous powerful individuals to convicted sex trafficker Jeffrey Epstein during the precise time period when systematic abuse of underage girls was occurring at his properties. Donald Trump's name appears multiple times throughout these documents, not as background noise, not as passing reference, as a participant in events where witnesses testified underage girls were present, as a frequent guest at properties where crimes were being committed, as someone described in sworn testimony as being, quote, very close, unquote, to Epstein during the critical years. The documents destroyed Trump's carefully constructed public narrative that he barely knew Epstein, that their relationship was superficial, that he banned the convicted pedophile from Mar-a-Lago early. The evidence, now public, reveals a relationship far deeper, far longer, and far more problematic than Trump has ever admitted. And his response to this exposure just handed prosecutors the kind of evidence defense attorneys spend their entire careers desperately trying to prevent their clients from creating. Welcome back. What you are about to hear is a forensic legal analysis of the most catastrophic, self-inflicted evidentiary wound in modern American political history. We shall examine the specific contents of the unsealed Epstein documents, dissect Trump's panicked response and subsequent deletion, analyze the legal doctrine of consciousness of guilt, and expose why federal prosecutors reviewing this evidence are experiencing what former Assistant United States Attorney Glenn Kirshner described as a prosecutorial Christmas morning. This is the deleted post that may destroy a presidency. To comprehend why Trump's deletion constitutes such devastating evidence, we must first understand what prosecutors mean by consciousness of guilt. This is a legal doctrine recognized in every American jurisdiction permitting juries to infer guilt from a defendant's behavior demonstrating awareness that they have committed wrongdoing. The classic examples are fleeing from police, destroying evidence, intimidating witnesses, providing false alibis, and making inconsistent statements that reveal knowledge of criminal conduct. Deleting exculpatory statements falls directly into this category. When a defendant publicly denies wrongdoing, then rapidly erases that denial, prosecutors argue to juries that the deletion demonstrates the defendant knew the denial was false and feared it could be proven false, thereby creating evidence against them in future legal proceedings. Former federal prosecutor Renato Mariotti, who spent years prosecuting fraud and corruption cases in the Northern District of Illinois, stated in an interview with MSNBC legal analysts, quote, "When I see a defendant delete a public statement denying allegations, my immediate reaction as a prosecutor is that their attorneys just reviewed the underlying evidence and told them that statement constitutes a provable lie that will destroy their credibility at trial. No competent defense lawyer allows a client to leave false exculpatory statements in the public record. The deletion is an admission. Unquote. Trump deleted his Truth Social post within hours of publication. The post, which multiple users screenshot before its removal, stated that the Epstein document release represented yet another politically motivated witch hunt designed to damage him, that he had banned Epstein from Mar-a-Lago decades ago, and that his relationship with the financier was merely social and limited in scope. Within 4 hours, the post vanished. Trump's account showed no trace of it. No explanation was provided for the deletion. No correction was issued. The statement simply ceased to exist, except it didn't. Because the internet is forever. Archives captured it. Screenshots proliferated across social media platforms. News organizations embedded the images in their coverage. The deletion became more newsworthy than the original statement. And from a prosecutor's perspective, Trump just created a timeline that tells a devastating story. January 3rd, documents unsealed revealing Trump's connections to Epstein. January 3rd, Trump posts categorical denial. January 3rd, Trump deletes denial after consulting with attorneys who presumably reviewed the unsealed evidence. The inference is inescapable. Trump's legal team recognized that his public denial contradicted sworn testimony now available to prosecutors, and they ordered him to erase the liability immediately. Let us examine precisely what evidence exists in these unsealed documents that would provoke such panic. The Jeffrey versus Maxwell defamation case generated thousands of pages of discovery, depositions, and exhibits during years of contentious litigation before settling. The settlement agreement included broad confidentiality provisions, sealing virtually all underlying evidence from public view. However, multiple media organizations and transparency advocates petitioned the court to unseal the documents, arguing that public interest and accountability for Epstein's co-conspirators outweighed privacy concerns. Federal Judge Loretta Preska agreed, ruling that the evidence should be released with limited redactions to protect genuinely innocent third parties and ongoing law enforcement investigations. The documents reveal that multiple witnesses were questioned under oath about Donald Trump's presence at Epstein properties and events during the 1990s and early 2000s, the exact period when Epstein was trafficking underage girls to powerful men. One deposition excerpt, now public, includes testimony from a witness identified only as Jane Doe 15, who stated she personally observed Trump at a party at Mar-a-Lago in 1994 where multiple girls she believed to be underage were also in attendance. The witness testified that Trump and Epstein appeared, quote, very friendly and comfortable with each other, unquote, and that Trump did not seem surprised or concerned by the presence of young girls at what was ostensibly an adult social gathering. When asked directly whether she believed Trump knew the girls were underage, the witness responded, quote, I can't say what he knew for certain, but the girls looked young, and everyone at those parties knew what was happening, unquote. Another document contains a 2016 deposition of a former Mar-a-Lago employee who testified that Epstein was a regular guest at the property throughout the 1990s and that Trump personally approved Epstein's guest privileges. This directly contradicts Trump's repeated public claims that he banned Epstein from the property after learning of his misconduct. When the deponent was asked when the alleged ban occurred, the witness stated they had no knowledge of any such ban during their employment from 1992 through 1999. The witness further testified that Trump and Epstein were often seen together at the property's pool area and that young women, quote, who did not appear to be typical club members, unquote, frequently accompanied Epstein. Flight logs from Epstein's private aircraft, subpoenaed during the Maxwell litigation and now unsealed, show Trump's name on passenger manifests for at least 7 flights between 1997 and 2000. While none of these flights correspond to trips to Epstein's private island in the Caribbean, where much of the abuse occurred, they do establish that Trump utilized Epstein's aircraft for domestic travel far more frequently than he has ever publicly acknowledged. Former federal prosecutor Joyce Vance, who served as United States Attorney for the Northern District of Alabama, analyzed these flight logs in a legal commentary published by MSNBC, noting, quote, "Flight logs are documentary evidence that cannot be explained away. If a defendant claims they barely knew someone, then prosecutors produce records showing they flew on that person's private jet multiple times. The credibility of the defendant's denial is destroyed. Juries understand that you don't casually hop on a private jet belonging to someone you barely know." Unquote. Perhaps most damaging, the unsealed documents include a deposition excerpt from a witness who claims to have attended a 1994 party in Manhattan hosted jointly by Trump and Epstein. The witness testified that the event took place at Trump's residence and that the guest list included multiple young women who appeared underage and who the witness later learned were part of Epstein's trafficking operation. When asked whether Trump seemed aware of these young women's presence and circumstances, the witness stated, quote, "It was his home. These weren't random people who wandered in off the street. Everyone there was invited. If you're hosting a party and underage girls show up as entertainment, you know what's happening." Unquote. This testimony, if corroborated and deemed credible by prosecutors, establishes what legal scholars call proximity and knowledge, two essential elements for potential conspiracy or complicity charges. Now overlay this documentary evidence with Trump's behavior upon its release. His immediate instinct was to deny everything publicly, to claim he barely knew Epstein, to assert he banned him from Mar-a-Lago. But then something happened. Attorneys reviewed the unsealed documents. They compared Trump's public denial to the sworn testimony now available to prosecutors, and they recognized the catastrophic liability. If Trump maintains in public that he banned Epstein decades ago, the court records show a Mar-a-Lago employee testified under oath that no such ban occurred during their 7-year tenure ending in 1999. Trump has just created impeachment evidence that prosecutors will use to annihilate his credibility before any jury. If Trump claims his relationship with Epstein was superficial, but flight logs demonstrate he utilized Epstein's private aircraft for multiple domestic trips, prosecutors will argue Trump is lying to conceal the true nature and depth of their relationship. If Trump denies knowledge of what was occurring at these parties and properties, but witnesses testify that the presence of underage girls was obvious and that Trump personally hosted events where they were present, juries will be instructed that they may infer Trump possessed knowledge of criminal activity. The deletion of the Truth Social post signals that Trump's legal team recognized all of these vulnerabilities immediately upon reviewing the unsealed evidence. The smart legal strategy, the approach any competent criminal defense attorney would mandate, is silence. Do not confirm. Do not deny. Do not create statements that can be weaponized against you later. But Trump's political instincts and psychological need to control narratives overrode legal prudence. He posted the denial. Then his attorneys intervened, almost certainly explaining that the denial contradicts documentary evidence and sworn testimony, and that leaving it public creates a roadmap for prosecutors to prove he lied about his relationship with a convicted sex trafficker. So Trump deleted it. But deletion does not erase legal liability. It amplifies it, because now prosecutors possess not only the underlying evidence contradicting Trump's narrative, but also proof that Trump himself recognized his public denial was indefensible when confronted with that evidence. This is what consciousness of guilt looks like in the digital age. Glenn Kirshner, former homicide prosecutor and assistant chief of the Fraud and Public Corruption Section in the United States Attorney's Office for the District of Columbia, stated in a YouTube legal analysis video, quote, "Donald Trump just did something I have never seen a defendant do in 30 years of prosecution. He created real-time evidence of consciousness of guilt that will be played for a jury if this case ever goes to trial. Prosecutors will show the deleted post, show the unsealed documents that contradict it, and argue that Trump knew he was lying, knew the evidence proved he was lying, and deleted the lie to avoid creating an evidence trail. Except he failed. The deletion is the evidence trail." Unquote. This matters because the Southern District of New York is not a political body. It is one of the most elite and aggressive prosecutorial offices in the federal system, with a conviction rate exceeding 93% in cases brought to trial. SDNY prosecutors do not unseal documents randomly. They do not release evidence without strategic purpose. The decision to unseal 973 pages of Epstein-related materials signals that prosecutors believe the public interest in transparency and accountability outweighs privacy concerns. That is a legal standard requiring substantial evidence that powerful individuals may have evaded justice. When you combine that judicial determination with Trump's panic deletion of exculpatory statements, you create the foundation for prosecutorial action. We are monitoring developments in real time. We have sources within the Southern District reviewing these documents. We are tracking every legal filing, every witness interview, every grand jury subpoena. If indictments emerge from this evidence, we will broadcast live. If you want unfiltered legal analysis that mainstream media will sanitize until charges are filed, subscribe immediately and activate notifications. Trump deleted the post, but the evidence remains. The witnesses are on record, the flight logs are public, and the consciousness of guilt is undeniable. This is not political theater. This is prosecutorial preparation. Do not look away.